Estate Planning Facebook group. So welcome to the group and thank you so much for being our guest today.
Thank you, Tara.
So for everybody watching, I'm with Laura Salsbury today from Generation Life, and Laura is going to talk to us all things about investment funds and why they are such a powerful tool when it comes to estate planning. And I'm really excited about this session because I have to admit I know next to nothing about investment funds or when to use them. And I mean, I really feel like it's important for particularly the lawyers in the group to be across how they work, when to suggest them, you know, what type of clients they're suitable for, so that we have you know, another tool in our estate planning toolkit. So I'm very excited to hear what you have to say today, Laura.
Thank you.
Before we launch into it, do you want to share a little bit about your background and, you know, where you're based and all of that, just so that the people in the group get to know you?
Yes, of course. So I work at Generation Life. We're the #1 provider of investment bonds or insurance bonds in Australia. I joined in April, but previously I worked in the annuity, retirement income streams, aged care and Centrelink space. So I guess that's kind of my background. I'm English, as you can tell, so I've been over in Australia now for just over 9 years. Certainly love the lifestyle here and the people and the weather, although Melbourne's not having quite the summer we anticipated so far, but never mind.
Are you saying it's quite hot over there, or?
No, gosh, no, it's 17 degrees in summer at the moment. Yes, it's pretty chilly for Melbourne.
Oh my God, well, I'm up on the Gold Coast, absolutely melting. So I'm a little bit envious, to be honest.
Are you? That's incredible. I'm in pants. I'm wearing trousers. It's just extraordinary in summer.
So, Laura, do you want to lead off? Tell us, what do we need to know about investment funds?
Yes, of course. So, a lot of the lawyers, accountants, and certainly quite a few or many financial planners don't really understand some of the nuances or features of investment bonds, or not understand what an investment bond can do. So actually, an investment bond is effectively a friendly society bond. It's an insurance bond, and it's actually governed under the Life Act. So what does this mean by governed under the Life Act? It means that the death benefit payout of a life insurance policy is tax-free and does not form part of the estate if it's structured correctly. There's actually many ways that investment bond can be structured, but it does mean that is a fantastic estate planning tool because it can actually bypass the estate for probate. And because it's a death benefit payout of a life insurance policy, it actually cannot be challenged in the court of law. No investment bond or insurance bond has been successfully challenged, and they've been around. They actually, insurance bonds date super, but it's actually a much smaller industry than super, and they haven't had any legislation changes for decades. But certainly more and more of the Australian community is starting to learn more about investment bonds and certainly what they can do to assist, especially in the estate planning arena. And we do get a lot of cases with regards to estate planning. So I guess if you're thinking about some of your clients, if you have clients who are looking to leave unequal inheritances, or maybe there's an imbalance between grandchildren and children, or they want to leave a philanthropic bequest to charities, or there's a moral obligation where they want to provide some money to a loved one that's outside the direct family. Now, I guess it's about really its family situation and dynamics and actually preempting any of these challenges. Because if you can preempt these challenges, the use of an investment bond or an insurance bond could be the perfect way to stop any of these challenges taking place. Now, firstly, investment bonds are actually a tax-paid structure. Now, Generation Life are effectively the tax man, which means that actually there's no tax reporting and there's no tax file number required. And they're taxed at a maximum rate of 30%. However, certainly a lot of our funds pay a lot less tax than that through franking credits, but also through our capital management ability and how we make provisions for tax internally. It is by far the most flexible structure available in Australia for what it can do. So some of the uses could be for education, saving for kids' education. We have a child advancement bond where people can leave money for their kids or grandkids. We stipulate the child at the commencement of the policy, and that cannot be changed. It cannot be challenged because it is a child advancement policy, and therefore they can set a date in the future where it transfers to the child. And it could be that they nominate restrictions on access. So they might be a little bit concerned that the child is hopeless with money. So they stipulate that the child, once it transfers to their name, they can only draw a certain amount out a year, which actually means that they're so flexible they can actually mimic a testamentary trust without the costs involved with a testamentary trust. And when you might be looking at a small amount of money, the cost involved with setting up a testamentary trust, it may just be worth it. So certainly for kids' education and passing money on to children is certainly a massive use. Another one is for clients who are capping out on their super contributions and their lifetime cap, 1.6 mil. The investment bond certainly is the next best thing when it comes to a tax perspective, and they are incredibly flexible. There's no restrictions on contributions because you can own as many insurance or investment bonds as you like. They can also be owned by any entity, so a trust can own them, like a family trust. And they're certainly a great way to restrict or quarantine income in trusts, because when you have family trusts with investments, a lot of times the accountants obviously do tax returns and, beneficiaries receive those distributions, pay tax on those distributions. And in some situations, bucket companies are set up to receive those distributions. So investment bonds don't actually distribute any income. And therefore, because they don't distribute any income, when held in a trust environment, it's a great way to quarantine those distributions. So if you do have clients who have family discretionary trusts and they don't need the distributions, the investment bond could be a perfect way for them to quarantine that income and compound the growth. So that's another area for trusts. Estate planning, of course, is a major area which we're here to talk about today. So investment bonds can be structured in many different ways where they can bypass the estate. So one area, of course, is that you have a life insured, the owner. The owner passes away or the life insured passes away, and it is a death benefit payout to the nominated beneficiaries. So it's a binding nomination. So we, on receipt of the death certificate, we pay out the proceeds to the beneficiaries within 2 weeks. So we'll sell down the assets and pay out to the beneficiaries. Because there's no tax reporting or no tax file number, they're very much under the radar. So really the only people that would know about it would be yourself as the lawyers, the accountants, maybe the financial planners, and of course us as the provider would know about it, and the owner. But actually the beneficiaries may not know about it, and certainly any of their family members may not know about it. So it's certainly a great way to be, it's under the radar. Whilst everything that flows through to the estate through a will is in the public domain and certainly can be challenged. Whilst investment bonds do not go through to the estate if there is a beneficiary and a binding nomination set up, and it's a death benefit payout of a life insurance policy paid to beneficiaries or to a charity. So it can be any entity actually can be the beneficiary. So a charity, a trust, individuals can be the beneficiary. Another way to structure a bond is actually through a future event transfer facility. So you might have clients who want to pass on some wealth to their children, and they can stipulate a date in the future where it transfers. So actually it might transfer on the death of the owner. So your client passes away and then we receive that certificate and we would transfer the ownership to the beneficiaries, i.e. the children, which is fantastic. The other option is a date in the future. So it could be when the child turns 40 or any date in the future, like when they get married or when at the birth of their first child. Or they could just come to us at any point and say, we'd like to transfer our investment bond over to our children. So the thing is that if your clients hold normal vehicles, those investment vehicles will be an estate asset, and then they'll need to get sold down, tax paid, or on going through probate to be paid to beneficiaries. With us, it's the most seamless and effective way to transfer wealth between generations. And we work with thousands of financial advisors who provide advice to clients and assist them when it comes to estate planning and use of the investment bond for estate planning purposes. But as I said, a lot of lawyers and accountants don't know they exist, and they're a very tax-effective vehicle, but certainly very powerful for estate planning purposes.
That's a great summary, and I don't know if you saw, I was writing down heaps of questions.
Yes, I saw that.
As you're going, because I'm just like, oh, what about this? What about this? So can I, just to drill down into the tax, so you invest or you get a lump sum, and then that is then invested in the bond?
Yep.
What type of investment is it? Is it just like a government bond, or is the phrase bond totally unassociated with like the government bond?
Actually, Tara, that's a really wonderful question, because investment bonds used to be your guaranteed style product, and they didn't seem very favourable we're talking sort of 20 years ago. They weren't so favourable when it came to the investment options. We are by far the most innovative in the industry. We have 49 funds available on, it's actually sees it like a platform. So it's effectively a tax structure like super. And we have 49 funds available that clients can choose from, and you can switch between the funds with no CGT or tax implications by those into the individual member. You can also obviously transfer ownership, and there's no CGT or tax implications by the transfer of ownership. But we have 49 funds available. We have many different asset managers like your Vanguards, your MLC Horizon, Petrol, Magellan, Legg Mason. So there is certainly a wide variety of funds available for clients to choose from.
Yeah.
And they can contribute to it on a regular basis. So it's actually a tax paid structure on death. So it's tax-free on death. It's tax-free on terminal illness. It's tax-free on PPD claim. It's actually tax-free on financial hardship as well. It's also tax-free on withdrawal post 10 years. So if your clients own an investment for 10 years, then they can make withdrawals post 10 years, and it's tax-free. Now, my predecessor, Jackson, used to say that no one should ever pay tax on a withdrawal of an investment bond. And that is because you can actually transfer the ownership to anyone at any stage, and you keep that 10-year intact. So as an example, you might have a high-rate taxpayer who owns the investment bond, and it's being taxed at a maximum rate of 30%. They might transfer it to a lower-rate taxpayer. That lower-rate taxpayer makes a withdrawal. The only portion they need to declare in their tax return is the gain component, because majority would end up being capital that they're withdrawing. So it's only the gain component. What they do, Tara, is actually get a 30% tax offset against their final tax bill that they can use against other income. So as an example, if a client made a withdrawal of 100,000 and of that 10,000 was the gain, they would declare 10,000 in their tax return, but then they would get $3,000 off their tax bill as an offset, which is really powerful. And that's if they withdraw within 10 years. Post 10 years, there's nothing to declare, no tax offset. It's very much a tax paid structure, so there's nothing to declare on withdrawal. So if your client holds it for 10 years and makes no withdrawals, there'd be no interaction with the ATO whatsoever.
Okay, so just so that I get the income tax right, so you, like practically you would set up the lump sum, contribute the lump sum into the investment bond. It would generate a return every year. Now out of that return, the income that it earns is just paid, or the tax on that is just paid straight to the ATO. It doesn't have to be remitted in the bond owner's personal tax return, and it's just kind of set and forget.
Yes, that's right. So if you're making withdrawals within 10 years, we're the tax man. We make provisions for the tax. The end user will not need to do any tax returns or declare anything. So it's actually really powerful for retirees, for estate planning, because certainly for them, if they're not in the early days, if they're not looking to make withdrawals, fantastic. The reality is even if they did make withdrawals, it's very unlikely that they would be paying tax anyway, depending on, I mean, it's all about the growth. That's what they declare effectively is the gain component, and it's always proportionate. Now, the other thing also is that you can contribute regular savings into investment bonds. However, because it's tax paid at year 10, it does mean that they've brought in this 125% rule. And what this stipulates is that you can contribute up to 125% of your previous year's contribution year after year after year. So if you invest 10,000 one year, you can invest 12,500 the following year. And the reason why is because it stops people from investing $1 million year 9, knowing full well it's tax free or tax paid at year 10. You know, that's why they do it. But ultimately, you can own as many investment bonds as you like, which is great. So people they might have 10 different investment bonds. And if they have 10 grandchildren, they might set up 10 investment bonds to transfer ownership to the grandchildren. So each grandchild gets given their own investment bond on the death of their grandma, or at a date when they turn 21 or 18 or 25.
Okay, and with the tax rate, that's 30%, or does it depend on an individual person's tax rate?
No, so because everyone is the same tax bracket, so everyone pays a maximum of 30% within the investment bond. However, what we do is we will add back franking credit within the fund, which ultimately means the client actually pays less taxes in Australian equity portfolio, but also we make provisions for tax, but we can offset losses in a portfolio against income gains, which ultimately means the client isn't paying tax when they don't need to. So we can actually make greater provisions and help the clients pay a lot less tax than your 30%. And it does depend on which fund they're invested in. If they're in cash, unfortunately, nothing we can do with cash. So cash is 10%, but then in the Australian equity portfolio, then certainly we could look as low as 10% as a natural tax paid within the structure. So absolutely. So it's a tax paid structure like super, and individuals would have no interaction with the ATO if they didn't make a withdrawal within 10 years. There's another thing I haven't mentioned actually, because it's again governed under the Life Act and it's effectively an insurance policy. You're an owner of an insurance policy. It actually means it's creditor protected. So if you have any clients who are self-employed or in high-risk professions where they could be sued for malpractice in the future, investment bonds are really powerful because if they're structured correctly in the individual's name, they cannot effectively be challenged or be touched by creditors. So they're governed under the Bankruptcy Act. So if you look under the Bankruptcy Act, one of the exempt assets that cannot be touched by creditors is an insurance bond.
Okay, well, so can I present a scenario to you, and can you let me know if you think it would work?
Yes.
So, say I'm presented with a client who's, you know, reasonably mature and has children from a first relationship and a new spouse, and they're really worried about the challenge, and they want to put some money into an investment bond for the spouse to just make sure that there's money that is protected. So then the investment bond would be a good strategy there to say, well, let's invest, like put, I don't know, 500,000 in a bond that we know goes to the spouse and can't be touched on an estate challenge. Would that work?
Yes. Yes, absolutely. So they've got two options of how they structure it. So your client would structure it in their own name, and they might decide to do a transfer of ownership to the wife or spouse on their death, or at a date in the future if they actually wanted to just give them the money. The other thing also is that with spouses, they set up joint ownership anyway, and ultimately on the death of the owner, it would just fall onto the surviving owner anyway. So that's a very simple strategy with the use of investment bonds. We find for blended families, they're widely used for people who want to provide for their children from previous marriage. Because a lot of times when they're in a new relationship or new marriage, if something happens to them, everything tends to fall under their current wife and the children. So what they do is they might set up an investment bond on the side for their children from a previous marriage, so that if anything were to happen to them, it will get paid out to those children, and at least those children get some of their legacy.
Yeah. And when the person who created the bond dies, how does that interrelate with that 10-year rule? Like, is it exempt?
Yes, it just brings it tax-free on death. That's right.
Okay. Yeah. And then so the 10-year rule is only if you want to withdraw capital while you're still alive.
Yes, correct. Absolutely. So it does, and you can transfer the ownership at any time, as many times as you like, but also that by transferring the ownership, you still keep that 10-year intact. So you might transfer the ownership at year 5, and then the new owner will have 5 years until they can start taking tax-free withdrawals. But a lot of times it's about doing the sums. An accountant would be terrific at doing the sums to work out whether there would actually be they'd have to pay any tax or not. Because that offset might end up being more beneficial to them if they're less than a 30% tax bracket.
Yeah. And so if they choose to nominate the beneficiary, so if they choose to nominate a recipient on death or a beneficiary, and then they change their mind, like they say it is for the new spouse, but then they get divorced, can you change it? Is that
yes? As long as they're still the rightful owner of the investment bond, they can make changes at any time. That's no problem at all. So they might actually change their mind down the line and say, you know what, no, if my kids become estranged, I'd rather not leave it to them anymore. So